I'm here at the office of Walt Adams, who is the Illinois State Counsel for the Fidelity National Title Group, which encompasses Chicago Title Insurance Company, Commonwealth Land Title Insurance Company, and Fidelity National Title Insurance Company. Today's topic will be about extended coverage.
Thank you. In Illinois, traditionally, we have raised 5 general exceptions on our owner's policies. In some markets, those general exceptions are insured over as a matter of course, or in other parts of the state, more information may need to be gathered. Charging for it, of course, varies from location to location. But traditionally, these 5 general exceptions have remained the same. These 5 general exceptions, and the deletion of those 5 general exceptions is what we refer to as extended coverage on your owner's policy. All 5 general exceptions relate back to matters which would not be found by examining the records at the courthouse. For example, our first general exception, rights or claims of parties in possession not shown by the public records. Not shown by the public records means we're not going to find this when we do our search of the courthouse of the public records. Why are we concerned with rights of parties in possession? Because in Illinois, the law is that if somebody is in possession of a piece of property, you are on notice of whatever rights they may claim in that property. For instance, if they get a deed to that property and actually bought the property from the prior owner but neglected to record their deed, you are on notice that they are on the owner of the property because they are in possession of the property. From the lending side, it can also be a very important issue. For example, if you're making a loan on an apartment building, you know there are tenants in that apartment building. You know they have leases. So you are on notice of all their rights underneath those leases, including perhaps that they paid a substantial amount of money up front for their leasehold rights and are only making annual maintenance payments thereafter. Obviously, that's a very important issue to a lender, just like it's a very important issue to an owner that they're not buying a piece of property only to find out they bought it from the wrong person. What do we do to get rid of the interest of rights and parties in possession? Well, typically we have a seller sign an affidavit at closing, or a statement at closing, it may not be a sworn affidavit, disclosing who all the rights and parties in possession are. On some more complicated files, we may also require surveys that will disclose who those parties are who may be in possession of the property, either by their buildings that are located there, their signs that are located there, or their use of the property as disclosed by the survey. Our second general exception is any encroachment, encumbrance violation, variation, or adverse circumstance affecting the title that would be disclosed by an accurate and complete land survey of the land. I have to be very careful how I say that, because this general exception actually mirrors one of our insuring provisions underneath the policy. If we do not make that exception, we are actually giving that coverage underneath the ALTA 2006 policies. Again, we're talking about matters of survey. These are not things we would find from an examination of the county records at the courthouse. How do we get rid of that general exception, you may ask? Well, it's pretty obvious. We need an accurate survey of the land. We get the accurate survey of the land, and that survey needs to be certified to some applicable standard of survey. The nationally recognized standard is the minimum detail standards for ALTA, ACSM land title surveys, though there are also Illinois-specific standards which may result in a lower cost of the survey that can be used from time to time. But when we get our properly certified survey, we then have to examine that survey in order to raise all the matters that would be disclosed. We're not simply going to take this exception on and assume the risk. We're going to take that exception on and replace it with a specific exception for the matters which are disclosed by the survey provided. The exception would typically read something along the lines of matters disclosed by ALTA ACSM land title survey prepared by John Doe surveyor dated 1/1/2001 job number 1 as follows, and then you would specifically list those matters. Now, sometimes people try to get away with a very general exception saying matters disclosed by the survey, including but not limited to, or just as disclosed by the survey. Well, not often we get away with raising that general exception that way. Typically, we have to be very specific. And of course, any matter you raise, then you have to consider whether they're going to require you to insure over it. But that's a topic for another conversation. Third exception, easements or claims of easements not shown by the public record. Well, it's very similar to the prior one. Often you have easements across property, whether they be acquired by prescriptive rights, by people using it for a long period of time, or whether they're under an unrecorded document. For example, you may have an old farm field that crosses the northwest quarter of the northwest quarter that's been used by the neighbor for 50 years to get back to his field. They never bothered to record an easement, but he does have certain prescriptive easement rights. If we waive this exception, rights or claims of underneath unrecorded easements, then we may have liability for that underneath our policy. So again, we have the same requirement as we had for general exception number 2. We require a survey that would disclose those type of matters, and if they're disclosed, then we would raise them specifically. Exception 4, any lien or right to a lien for services, labor, or materials heretofore or hereafter furnished and imposed by law and not shown by the public records. This is the great boogeyman of title insurance in the state of Illinois. This is mechanics lien coverage. Mechanics lien coverage in Illinois is a very risky issue because the lien doesn't have to be recorded to be a valid lien. They can record their lien for a certain time period after your transaction closes and still have a valid lien that will preempt the rights of the parties you've just insured. So when we have new construction, we have to go through certain steps to make sure that everybody's been paid and there will be no mechanics liens. Again, that's a topic for future discussion. But typically, on most residential sales, we rely upon a statement by the owner that he hasn't had any work performed in the last 6 months. Or if he does have certain work performed in the last 6 months, then we go to the next step to make sure that everybody's been paid. But that is the great boogeyman in Illinois, one of the highest claims areas for every title insurer in the state of Illinois. The 5th exception is taxes or special assessments which are not shown by the public records. This general exception has become less and less important over the years as more special assessments are now part of the real estate tax bills. But traditionally, there have been a lot of special assessments on Illinois real estate property which you would never find by an examination of the county recorder's office. For instance, you may have a drainage district that was established in the county in 1875 and was established by a court order. And for years and years, it's been a drainage assessment district where some farm wife has been writing out the little assessment bills and mailing them to people from her kitchen table. Traditionally, that was a problem in the state of Illinois, but like I said, more and more of these have gone by the wayside and are now part of the real estate tax bill. So it's become less of an issue for us. Again, we rely upon the representation of the seller in his title affidavit, or what we call the ALTA statement in the state of Illinois, that there are no special assessments. And we, quite frankly, also rely upon the local knowledge of our title professionals to know what parts of their county there may or may not be drainage districts or other districts which could have incurred special assessments on the property. So those are our 5 general exceptions, and those are how we deal with them. Again, if you're a consumer and you have issues with any of these matters, please consult with the attorney of your choice. If you're in the industry, please consult with your Fidelity National Title Group underwriter. This is a general discussion. It's not all-inclusive, and I'm expressing my own views and not those of the company. Thank you.